Hi everyone, my name is Dylan Grant and welcome to part 9 of my presentation on Ontario Superior Court of Justice Motion Record and Order. Okay, I'll be going fast. You'll still see some things that you've already seen. I'm going via the tabs for you to understand what the court did. The court should not have accepted this. It was just all nonsense which was presented by the lawyers, and it was still accepted by the court of law. Unbelievable. Okay, please feel free to pause and read if I'm going too fast. All right, thank you. So now we are at tab K. Notice of examination dated May 6, 2020 and September 1st 2020. Feel free to pause and read as you go along. Okay, thank you. We have been through this anyway. We have been through this one already. But this is what I'm comparing with what the court had and what I had. All right, thanks. Okay, notice of examination dated May 6, 2020 and September 1st, 2020. Not sure what this is about. We'll see. Long-term disability, the Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Services, Inc. only. Where was the amended statement of claim with Bell Mobility, Inc.? Where was the amendment? The amended statement of claim with Bell Mobility, Inc. Okay, let's go. Deception, I'll read this. Examination for discovery, September 26, 2019, letter received from Neymark Law, Grant versus Mobility. As you're already aware, I'm going through this, all right? It's here, clear for you. Okay, it's examination for discovery, wrongful dismissal, scheduled for Friday, May 15, 2020 at 10 a.m., etc. Okay? October 3rd, 2019, court file, retrieve for motion 2021, Grant versus Manulife Insurance and Alliance Insurance, right? Examination for discovery, long-term disability, scheduled for Friday, May 15, 2020 at 10 a.m. See the difference, okay? Neymark Law said, Bell Mobility, Superior Court says, Grant versus Manulife, okay? For the 15th, May 15, 2020, okay? Above, two different communications on examination for discovery on both my cases. Was this an incompetence of Neymark Law Firm or was this an intent to deceive? I only received one letter. The deception continued. May 6, 2020, email received from Neymark Law to postpone the discovery from May 15, 2020 to September 29, 2020. See? Postponed from May 15, 2020 to September 29, 2020, and that was Grant versus Bell Mobility. Okay? On May 6, 2020, the court file retrieved from motion 2021, all right, confirmed a change in date from May 15, 2020 to September 29, 2020. What were we talking about? We're talking about Grant versus Manulife Insurance. Okay? So I got one information while the court got another, okay? But still for examination for discovery long-term disability. August 18, 2020, received email reminder for upcoming discovery. Attachment indicated wrongful dismissal. Tuesday, September 29, 2020. Right? Remember that letter this was from Denise, August 18. No mention of long-term disability. It was for wrongful dismissal. But on August 20, 2020, email received from Samantha, which was sneaked in, to advise that the examination for discovery was for both wrongful dismissal and long-term disability, sneaked in after a year and a month. Okay? This law firm, wow. They could hire me, They could have hired me. I'm a very detailed person, as they can see. Okay, please feel free to review. Thank you. All right. Email received on April 2020 to remind of the examination for this discovery, wrongful dismissal. Still no mention of the examination for this examination for discovery, long-term disability, cancelled in August 2020. I just brought this forward as a reminder. Okay. All right. It says April 21st, 2020. It says further to your seat phone call your recent phone call, please see the attached letter regarding examination for discovery scheduled for May 15th. You see that? Okay. April, and it says 20 September. This is what was included, eh? This was what was included in the email. And it says September 26, 2019. And you can see grant versus mobility. All right. I'm just jogging your memory. All right. Thank you. May 6, 2020. And it says, unfortunately, we are unable to agree to proceeding via video conference. We have confirmed a new date, September 29, 2020, to proceed with the in-person examination. And this, they were talking about the grant versus mobility. All right. August 18, same thing. Just a courtesy reminder regarding your upcoming examination for discovery schedule to proceed on August 29. And I have attached letter here for ease of reference. Okay, so Denise Coy was on the previous slide too, right? That email, Denise Coy, right? As you can see. Okay, April, May 6, and August 18. Reminding me of the examination for discovery, grant versus mobility, which is wrongful dismissal. Okay. All right. So this was what I got first. Wrongful dismissal, Friday, May 15, 2020, grant versus mobility Inc. When it was changed, okay, May 6, 2020, and it still says grant versus mobility, which is wrongful dismissal, and it says the new date is September 29, 2020. Okay, you can recall? All right. And then now, Superior Court. So as you can see, May 6, 2020, this is from Neymark Law, and it says grant versus mobility when the changes were done Tuesday, and then the new date was Tuesday, September 29, 2020. Wrongful dismissal. But the court, Ontario Supreme Court, had the Manufacturers Life Insurance Company and the Industrial Alliance Insurance and Financial Services, and this we know definitely as per the statement of claim is for long-term disability. All right, and here it says Tuesday, September 29, 2020, and it says examination for discovery. All right, so misled by Neymark Law. Yeah. Feel free to review. I've already went through this. That's why I went through so quickly. So I hope you were able to understand what I was saying. Okay, thanks. And here, as you see, the date May 6, 2020, and this is the from the motion. This is from the Supreme Court, that says the Manufacturers Life Insurance Company. Okay, misled by Neymark Law, because on May 6th they still stated that it was grant versus mobility. Okay, please feel free to review. Thank you. The incompetence of Neymark Law firm continued. The only thing that Neymark Law did to my case is what was to create confusion. Let me read it again. The only thing that Neymark Law firm did to my cases was to create confusion. Yep. And I believe you would agree with me, right? Neymark Law did not involve me at any time, but intentionally made a mess of my cases. Neymark Law's intention, again, was to postpone the examination for discovery dated September 29, 2020. They succeeded in August 16, 2019. They succeeded in May 15, 2020, and now they did it again in September 29, 2020. This lawyer wasn't representing me. They must be getting paid from somewhere, right? Why go through all this without payment? Yeah. What do you think? Okay. Some of the information below was taken from above. It was same for my wrongful dismissal mobility case. coerced by Neymark Law in July 2019 to transfer my cases. The examination for discovery long-term disability scheduled for August 16, 2019 was cancelled. I waited for a rescheduled date from Neymark Law, but there was no mention of a long-term disability case for over a year. It was sneaked in August 2020 as part of the upcoming of the upcoming scheduled examination for discovery dated September 29, 2020. Trying to go fast, so forgive me. Neymark Law did not prepare me for the examination for this discovery, wrongful dismissal, or long-term disability. Okay. As you can see here, retained lawyer on July 26, 1 year and a month. Later, I have never met with the lawyer to discuss any of my cases. So Denise, on August 18, going through this again, right? August 18 made mention only of the examination for discovery wrongful dismissal, as you can see here. All right. Grant versus Mobility Inc. Nothing regarding long-term disability, right? And then it was Samantha now, 2 days later, as you can see, 2 days later, August 20, 2020, okay, stated, and just being casual with it, eh? She said, hope you're doing well. Denise has advised that examination for discovery are scheduled to proceed on September 29, 2020 with respect to your LTD and wrongful dismissal. Now, did Denise advise me about long-term dismissal? Long-term disability, I meant. No. All this time, April, May, August, Denise was talking about Grant versus Bell Mobility. But Samantha, you see, it's like Neymark Law firm train people, or they're training their lawyers to lie. Maybe, I do not know if all law firms are like that, but I can read and I can understand. It's all about Grant versus Mobility. But now she's going to say, Samantha Bray, who actually wrote up affidavit lying on my character too, right? Samantha Bray, right? Just like how she's lying here. I hope you're doing well. Denise has advised that examination for discovery are scheduled to proceed on September 29, 2020 with respect to your LTD and wrongful dismissal files. Denise did not inform about LTD. Okay? And I believe you would agree with me. Anyone reading this and following me, and understanding what I have been saying. Okay, please feel free to review. Thank you. The deception of Courtney Madison, Neymark Law. After I requested statements of claim, reviewed and commented for answers to be discussed at the meeting, I requested a meeting for the first time. Sorry, it wasn't going to be in person, right, or via Zoom, right? It was via phone, and it was scheduled for Friday, September 25th, 2020 at 2 p.m. Finally, I thought, my first meeting with the lawyer after several attempts for over a year, July 2019 to September 2020. Prior to the examination for discovery, dated Tuesday, September 29, 2020, I requested a meeting, which never happened. Lawyer Courtney Madison had no intentions of meeting with me to discuss any of my cases, which she stated several times were complicated. Lawyer Courtney Madison made my case, or I should say cases, her own, and was only allowing a 2-hour prep the morning of the examination for discovery. Lawyer Courtney Madison realized that I had her cornered based on my questions on the statements of claim and other evidences in my possession brought forward. Therefore, delayed the meeting to find a way around my questions. I have included the inconsistent reasons provided by Neymark Law Firm, which you have already seen. But again, I will refresh your memory as we go along, okay? Upcoming examination for discovery, September 29, 2020, was fast approaching. I had not met with a lawyer, as I did indicate. So here, September 8, 2020, I received this email after I spoke with Courtney Madison. I spoke with her briefly. It was no like a meeting per se, right? She said I asked about a statement of claim. Yeah. Okay. Then she said, I've asked Sam to send you the statement of claim per your request. Okay. And Samantha Bray, she's a law clerk. Okay. Samantha Bray, 2 days later, 2 days, don't know why. 2 days, took her 2 days. And she said, as per your request, attached, please find a copy of statement of claim for your long-term disability and wrongful dismissal files. I apologize for the delay in providing you with copies of same. Okay. September 22, 2020, okay, from Denise Coy, right? She was making the arrangement, okay, for Courtney and I to meet. I have arranged a prep call for yourself and Courtney for this Friday, September 25th at 2 p.m., right? And I wanted a Zoom meeting. So she said, your examination for discovery has been changed to proceed via Zoom. Please see details below. It was supposed to be Zoom, but no, it did not. It turned out just to be a phone call, which actually never happened. A call came in, but briefly, postponing. Okay. It wasn't about the meeting. I did get a call, but it was not about the actual meeting to discuss my claim. Okay. Feel free to review. Thank you. Okay. Neymar Claude had planned to meet with me for only 2 hours, prior to the time of examination for discovery. Though this lawyer I didn't real she did confess, Courtney that is, and I have it in voice message and in one of those that I recorded and I shared with you, right? That she said she took stuff out. She took stuff out and she did not inform me. All Courtney was gonna do is just give me like a 2 hour prep time before the examination for discovery. On the day off, she was just gonna give me 2 hours. So it would have been the examination for discovery was scheduled for 10 o'clock, and then would have met at 8 o'clock, and then she would speak with me. So she was trying to blindside me, I guess, because she removed stuff. Yeah. So I would have lost my case. Or say cases. Yeah. Right, as you can see here, Denise Coy has reminded me, I have arranged a prep call for yourself and Courtney for this Friday, 25th. Right, and because of that pep talk, right, Denise changed my pep talk for the day of the examination for discovery was changed from 8 o'clock to 8:30. So it said a second prep talk has been arranged for morning of event, September 29th at 8:30. Okay. If I had the call with Courtney, which was scheduled for Friday, September 25th at 2 p.m., I just needed basically like an hour and a half with Courtney. Feel free to review. Okay. Thank you. All right. Then I messaged Denise to say, please advise Courtney that one of my discussions on Friday is regarding the statement of claim. That changed everything. Oh my God, changed everything. Yeah. Feel free to review. Thank you. Naymark Law. Ryan Naymark and Courtney Madison had joined forces with Usaim of the Dairy Bell defense lawyer of Hicks Morley Law to ensure I lose my cases. See the inconsistent reasons, okay? And I will go through it again, okay? On Friday, September 25th, 2020 at 12:45 p.m., the day of the meeting scheduled for 2 p.m., Courtney Madison stated via email, I'm waiting on the defense counsel. We are trying to organize a schedule for Tuesday. She said the defense lawyer will call her around 3 o'clock. Okay, 3 p.m. Friday, September 25th, 2020, later in the day at 4:55 p.m. Receive call. Remember, our meeting is supposed to be at 2 o'clock, eh? 2 o'clock. Then she said, if anything, the meeting is going to be about 3:34. But instead, I received a call same day in the evening at 4:55 p.m. Not a woman of her word at all, okay? Received call from Courtney Madison to inform that B, she was unsuccessful in speaking with the defense lawyer and that it was best we hold off on our meeting so as to better prepare me. All these I have in writing. That's why I can basically, you notice I can say it. Either put it in quotation or I put it in my words. Basically, that's what she's saying. Okay? As a matter of fact, the call. Yeah, so that's what she was saying. Whenever it's a phone call, I tell you what she's saying. I kind of quote her word for word, but that's what she said. Okay? Like on that line. Okay? And when you see it in quotation, that means in email. So therefore, I'm quoting her word for word. All right. So C, she also on the call, she also said the wrongful dismissal case would not be included in the examination for discovery on Tuesday, September 29, 2020, because more time was required to prepare. Okay? Now, there's proof. So although she said that, and I'm not lying on her, she had it in email eventually. All kind of excuses. She wasn't consistent. She gave me various reasons why the wrongful dismissal case would not be included. Okay? This is a wrongful dismissal case that I had waited 10 months for an examination for discovery. July 2019 to May 2020, which was postponed until September 2020. Waited 4 more months, right? A total of 1 year and 2 months to be told. More time was required because at no time Courtney Madison Neymark Law sat with me to discuss my cases. She did not expect my response to the statement of claim, therefore was unsure of what to do. Okay? She needed the defense to guide her. Our meeting was postponed to Sunday, September 27, 2020 at 4 p.m. Sunday, September 27, 2020. Okay, call received from Courtney. She was on time at 4 p.m. to inform that she was unsuccessful in speaking with defense lawyer. Defense called the shots, eh? I want a personal meeting. Remember, okay? How does the defense? I don't understand why include defense in my meeting with Courtney. What does the defense have to do with the meeting? Okay? Nothing. But she just didn't want to answer questions. Okay. Meeting postponed again until Monday 28, 2020. Monday, September 28, 2020. Call received in the morning. She did say it's gonna be late afternoon or so, right? Like in the afternoon thereabout. But I got the call in the morning. Got caught off guard. I was informed they, Neymark Law and Defense, had misguided me towards an examination for discovery. And as you know, if you look it up online, you will know definitely that this lawyer, Courtney Madison, is lying, okay? Because a discovery comes before mediation, okay? And it makes sense. Discovery comes before. That we have to get familiar with what I have and with what would other party have, right? Till if anything now will come to a settlement. How can I come to a settlement when I do not know what's going on? Yeah? That doesn't make sense. So she's taking me for a fool. She's taking me for a ride. This lawyer has breached the contract over and over and over. So here I said, she said that they had misguided me towards an examination for discovery, which should have been a mediation first. Therefore, the examination for discovery, dated September 29, 2020, will have to be cancelled. On the same day, email received at 2:19 p.m. She said, I do not have the wrongful dismissal documents yet. And F, Bell proposed that they want to divide up your examination into wrongful and dismiss and disability examination. All right? Wow. Please feel free to pause and read. If you didn't understand what I was saying, it's all there. All right. And I wasn't lying when she told me on Friday that wrongful disability would not be included. It's in the email. See? Proof. All right. Please feel free to review. Thank you. And there was a G. I didn't see this one coming. And as we already went through it, another excuse. All right. Please feel free to review. I'm trying to go fast, so forgive me. Wow. She said, in writing, I understand that there may have been some confusion when rescheduling the examination that was booked before we were retained. Our office, I believe it was both the LTD and wrongful dismissal issue on exchanging documents and communicating with counsel last week. We came to find out, how many months, over a year later, came to find out that it was only the long-term disability matter that was scheduled. Wrongful has to happen separately. As such, those documents have not been produced to us as yet. A year later, Courtney Madison already had in her possession the statement of claim, wrongful dismissal, and other documents from Sanford to Marking Law, September 2019, right? Since September 2019. Now, you would say I am a patient person, right? Yet they make me out to be this monster when they defame my character. When they discuss me with the acquaintance, who else could they do this to? People would have flipped already, People would have flipped. I was patient. I knew that this lawyer was doing wrong by me, but I didn't have anywhere to go or anywhere else. So I tried to be patient. I tried to, not to, say anything really. Because they have my case, and I really was hoping that they will wise up at some point and do right by me. That's what I was hoping all along. Wow. Feel free to review. Thank you. Okay, this is a proof. When you say I extracted it, that's what I read on the previous slide right here. So please feel free to review. I understand that there has been some confusion. All right, and feel free to read. I've already went through this on a previous presentation on Name-Mark Law. Please feel free to review. Thank you. Examination for discovery long-term disability dated August 16, 2019 cancelled. This was the only examination for discovery that was scheduled by Benjamin Law Firm. For over a year, Name-Mark Law deliberately informed me of an examination for discovery wrongful dismissal under false pretense. Name-Mark Law had not involved me at once in my cases to be told this error was before they took my case. Nope. Name-Mark Law was following the instructions of Ixmorley Law and Nickelodeon Law to delay my cases, then tried to force a mediation after so many damages. I know I've been repeating myself, but just let it just I'm bringing it forward. I brought it forward because this is a nonsense accepted by the Superior Court of Justice, And I'm showing you here that this law firm, Name-Mark Law, did wrong by me. Okay, please feel free to review as I go along. Thank you. Conclusion. Name-Mark Law had no intention of assisting me with my cases, and I believe you would agree with me. All right. Name-Mark Law remained consistent. Lawyers' loyalty to ensure that my cases would not receive a fair trial and would be thrown out. I have some points here, okay, and I guess you would agree. I retained Benjamin Law Firm in February 2019 for long-term disability. An examination for discovery was scheduled for August 16, 2019. I retained Sanford to Marking Law in March 2019 for wrongful dismissal. Statement of claim and statement of defense were prepared awaiting a scheduled examination for discovery. I retained Name-Mark Law Firm in July 2019 for my motor vehicle accident and was coerced to transfer the above cases that were already separate, okay, which would have been easily revised with the necessary information to litigate. Naymark Law, right, got the cases in ready form. They were ready for examination for this discovery. All Naymark Law should have done was just review and call me in office for us to go through, None, that didn't happen. Brother. Then it was in July, as I said here, why were the cases combined, amended in July 2019 without my knowledge? See, they were there to confuse situation, okay? To be told over a year later, September 2020, that they should be separated. That now my cases should be separated. Okay? Why were motions submitted to the Superior Court of Justice with the amended statement of claim if they should have been separated? The separated statements of claim were also included in the motion. So you see, the court of law is also confused. No, not confused. Plain along. So the amended statement of claim had manufacturers insurance, manufacturers life insurance, and industrial alliance insurance, and Bear Mobility Inc. Okay, that's one combined. Then what was also submitted was the manufacturer's life insurance and alliance insurance, one, and another statement of claim for Bear Mobility Inc. So basically 3 different statement of claim. Okay. However, the number on the amended statement of claim was still the same, I believe, for the Manulife insurance. It was so confusing. Okay, what I hope you were able to understand when I actually went through explaining what the lawyer did, right? And what it should have been, okay? And I said here, why the Naymark Law informed me of an examination for discovery wrongful dismissal for over a year, when the Superior Court of Justice had submitted to the law firm that the examination for discovery was for long-term disability. The same discovery, long-term disability, that was cancelled on August 16, 2019. Okay? Naymark Law did nothing for the wrongful dismissal claim. Why did I have to wait over a year to be told that there would not be an examination for discovery, but a mediation? Because I was misinformed? Naymark Law provided false information, which was against the law. As you can see. Can you see the deception? Okay. Please feel free to maybe review this presentation if I was going too fast, but you have already already prepared for my other presentation, what it should have been and what the lawyer did. So I just summarized here, okay? Please feel free to review. Thank you.